Judge Muriba will give the final issue directions on time.
Okay, this is how we'll proceed. The applicants will have 20 minutes to argue their application. Any party in support of that application will have 5 minutes to support that application. And the respondents will have 7 minutes each to respond to the application.
The application for the constitutional bench is made effectively. The subject matter of removal is being given only 5 minutes. I plead with you, you must take it.
My Lord,
where are we going with?
Please,
I'm speaking. Will you speak,
Dr. Kamino?
With respect, will you sit down, please? Kamino is talking. Will you sit down? I don't mind much what you want to
do. Under the rules of this court, senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down. I, as senior counsel.
I will not sit down. We're not practicing law. You are still doing breastfeeding.
That is also. So, my lord, I want
Excuse me. Dr. Kamuna, finish what you are saying.
What I'm saying to you, my lord, we need a hearing process, and this court is going to provide that hearing process. Let the lawyers say what they want to say. What are we hearing for? Let us not have some people calling themselves professor or senior counsel titles that don't mean anything at all when it comes to this.
I think they mean something, Dr. Kamina. They do mean something. Those
something means something when it's you and you approve it. Yeah. My lord, all that I'm saying to you, let people talk. Let people address you.
Okay.
Where are we going?
People will talk.
When the country is burning.
Dr. Kamino, you have made your point, please.
Yes, thank you very much.
You have made your point.
I have made a point.
Yes. Professor.
We have a Deputy Chief Justice who has been removed irregularly. Let us be given time to be able to address it.
My lord, I think those of us who are representing substantive respondents, we all agreed that you have given orders that
to ensure the relevant office remains vacant until this case, through a judgment, pronounces itself. But my lord, why are we here and why is there a heated discussion? We are here and we are having a heated discussion because what is the clear intendment of the Constitution is being circumvented, so that to ensure that the subject matter is not preserved. My lord, this would be akin to a situation in which somebody comes and says, I am being evicted and my things are being removed. A court says, stop the eviction process up to where it has occurred. Then the respondent comes and says, no, lift those orders so that I can carry those things that it is alleged I was unlawfully taking. So that, my lord, in the face of the fact that what conservatory orders are supposed to serve, I beseech you, and I believe the entire country would expect that there has to be preservation of the subject matter of the applications. So that, my lord, now, that being the context, it is absolutely important that we do not lose sight of the moment. It is heated, one, because there was a sitting on Saturday. Before application responses could be made, we found ourselves here. We were supposed to come here on Thursday. We are here on Tuesday. So that, my Lord, and there are a lot of matters that directions must be given. So that, my Lord, that context would be absolutely important, because when all is said and done, the critical issue before this court is a right under Article 25, the right to fair hearing and human dignity. Right to fair hearing and human dignity cannot be violated even during an emergency. My Lord, that being the background, I ask you, and we shall be asking you, because that is the context where all these things are happening, that you ensure that whether heaven falls, the High Court must stand up, if for nothing else, for the right to preserve the subject matter until this High Court pronounces itself through a judgment. Because that is express law. Having said that, my Lord, I come to the prayers. The prayers are like this, and we had already indicated about 6 substantive prayers. The linchpin of these substantive prayers, my Lord, is the fact that the Deputy Chief Justice, under Article 165, does not have the power to appoint or assign, as the words used by the Constitution, members of a certain court to hear the matters. My Lord, Article 165(4) is very clear. Where the Constitution says the President and Article 149 can nominate Kindiki, there is no argument that is made that a minister or somebody else can be made. We expect that there can be no feasible argument where the Constitution has expressly said that the Chief Justice shall do something. The Chief Justice in this case did not empanel this bench. My Lord, we are urging this honorable court to make a finding that unless the Constitution is interpreted or amended to give the Chief Justice, the Deputy Chief Justice, the power to empanel a bench by express reading of the Constitution, she cannot be able to do that. Issue number 2, my lords, is that it is not for nothing that it is one of the biggest occasions that the senior most judicial officer is the one that the people of Kenya, judicial power in the first place vests in the people. Judicial power by express words of the Constitution, or to do this appointment and to act under Article 165, was vested on the Chief Justice. It is not by accident. It is by the express intention. So that, my Lord, on the face of it, when a state officer who is not directly mandated to do something ends up doing it, under public law judicial review, it is done every day. You did not have the power under statute or the Constitution to do that. There are so many cases, starting with Madho versus Republic. I think it was sometime in 1974, where somebody at City Council did something where the law did not allow that person to do that. So that, my Lord, all these cases we are aware of. So that, my Lord, as far as Article 165 is concerned, we submit that that is not possible. But, my Lord, this argument is developed a little bit further by the petitioner's applicants. Because the petitioner's applicants are saying that the Deputy Chief Justice, having usurped the powers of the Chief Justice, she proceeded to do 2 things. 1, to sit at night to appoint a bench, and to authorize that bench that sat on Saturday to conduct their business on Saturday. My Lord, those are irregular, because as we are saying, when this is not a matter of public emergency. Of course, it was a matter of public emergency before the National Assembly. But having found herself in that situation, she decided to treat this matter as one of public emergency. Then, my lord, she directs come and sit on Saturday. We have set out in our applications and in our affidavit. There must be certain circumstances under our laws, the High Court Administration and Organization Act, that can justify for any bench to sit outside on Saturday and Sunday. There must be express reasons. Those express reasons, as we sit here, agreed. We still do not know them. And if we do not know them, every Kenyan would be aggrieved by a decision made in these circumstances, would have every reason to be concerned that from the word go, there was a conspiracy to commit injustice. My lord, all of you have been honorable members of the High Court. There cannot be, where there is no public emergency, for occasions to arise that for the first time you would effectively be accused. You engaged yourself in a conspiracy to undermine the Constitution and to defeat it in a manner that would amount to treason. So that, my lord, the point that we make is that in the absence of a public emergency, what has so far happened is not only just unconstitutional, but something that would amount to violation of the Constitution and something that would amount to violations of the Penal Code as far as the issue of observing justice is concerned. My lord, for argument's sake, we proceed to make that argument. Let's assume that there was an emergency. We submit there was none, but let's assume there was one. If there was an emergency, then it was incumbent upon the Chief Justice to read, and they were in the newspaper and in the news, all these cases that honorable judges of the High Court from various stations had recommended for a bench to be appointed to hear them, to consider them, and place them for hearing on Saturday, and to fast-track that hearing. But, my lord, what is it that happened? My lord, what actually happened is that you have a situation whereby the respondents, who are basically agents of the government of Kenya and its various appendages, have gotten their applications to be satisfied and for a bench to be specially convened to sit, because from the standpoint of the petitioner, to set aside the conservatory order in order, as the petitioners contend, the violations of the Constitution may be completed. My lord, justice in this case, if it means anything, it must mean a very simple issue. The multiple violations of the Constitution that are already ingrained and embodied in the various applications, we cannot allow them to be completed, because this is what it's all about. This is what the decisions of the Chief Justice was all about, to complete the serious violations of the Kenyan Constitution. By your oath of office, your lordships are committed to stop a respondent and a government and its appendages that act in this manner. My lord, what does it amount in law for the Chief Justice to say you have about 15 or 20 cases, as I hear from my learned colleagues who have been in this matter longer than me? I'm here today for this matter. And I'm here because
circumstances, the Chief Justice may have delegated these powers to the Deputy Chief Justice. It is our humble submission, Your Lordship, that the powers and the functions under Article 165, Clause 4 are not capable of being delegated. Further to that, Your Lordship, you seek leave under Article 159 of the Constitution, which provides that, Your Lordship, that judicial power is derived from the people and shall be exercised by the courts and tribunals established by this Constitution for and on behalf of the people. That article, again, clearly indicates that this power under Article 165, Clause 4 is not capable of being delegated. However, the Deputy Chief Justice herself sit at night, in the wee hours of the night, ungodly hours, and constituted this bench. Your Lordship, it's our humble submissions that Article 10 has only arrogated that function again exclusively to the Chief Justice, and that the Deputy Chief Justice has no power under Section 10 of the High Court Organization and Administration Act to order you or to authorize you to sit on an odd day like that or the Saturday. Your Lordship, permit me to draw your attention again to the case of Kia Omtata. When you retire and the judgment will be highlighted by my learned friend, it is of importance, Your Lordship, that you look at paragraph 192 of that judgment. It has given the circumstances under which the Deputy Chief Justice can act in the absence of the Chief Justice. One is if the Chief Justice is indisposed, if he resigns, if he is dead, or if he is voted out of office. The question of leave, to which we are submitting without knowledge whether that is the circumstance that led to the allocation of powers by the Chief Justice, is not one of the grounds or reasons that the Chief Justice can exercise, the Deputy Chief Justice can exercise the exclusive powers meant for the Chief Justice. Finally, Your Lordship, all these averments contained in our affidavit have not been controverted by the respondents through a replying affidavit. They have only filed the grounds of opposition, to which they shall bring to your attention the case of Container, which has been distinguished by the case of Okia Omtata. The grounds
request Council to give us specific reference to Okia Omtata has been mentioned by two counsel. Is probably the most prolific litigator in the history of.
For you as a court to rise to the occasion. This court has defined the Constitution as a transformative constitution. And this was done by these very courts, differently seated in the BBI case, David Lee and others, versus the Attorney General. And this is what the court said about the Constitution 2010. It is a constitution.
This litany of irregularities, this honorable bench found time to give a hearing today when they say they are only available to us. Let justice be seen to be done. The only agency that one is able to trace is that somebody somewhere is in a hurry to vacate the conservatory orders that preserve the substrata of the petitions for very weighty issues in order to swear in somebody somewhere. Yes. You are concerned with the Constitution. Permit me to point out with a lot of respect, my Lord, to your leadership. I have gone through these things during the radical surgery, and I doubt that we have seen the last of the radical surgery. And my plea preserve
individuals who want to bail at night because probably they have been in the bar, they have drunk a lot, and they want to bail in the rush of the judge's home or the chief justice's home, I will be granted bail. It's a beautiful custom, beautiful practice, and I invite you very respectfully, my lord, that you endorse it in your ruling. Give justice to people. It was a good practice. Instances like in Mombasa, Your Honor, you would have foreigners who have had children, or still minors, who were our local girls.
and in the protection of the sovereignty of their republic. And that republic is underpinned by having continuity in the institutions of government, be they the legislature, be it the judiciary, or be it the executive. We shall be submitting that the public interest is in favor of an expeditious disposal of matters that affect the continuity of government and that imperil the stability of the state. And that human rights are not only accorded to individual applicants, they are also accorded to the collectivity called Kenya. And
they ignored, my lords and your lordship, that the law expressly provides instances or gives direction as to when the Deputy Chief Justice shall exercise the powers of the Chief Justice. And my lords, this is expressly set out at Section 5, subsection 2A of the Judicial Service Act, Cap 185B of the laws of Kenya. The Judicial Service Act expressly provides, my lord, that the Chief Justice can deputize, or the Deputy Chief Justice will exercise the powers of the Chief Justice in the absence of the Chief Justice. My lords, the CTS and my learned friend Professor Rigathi referred to this. There are only 2 professors senior counsels here, so it must be correct. My lord, in the CTS, under the sub of this proceeding, my lord, were obtained after the impeachment proceedings, after the act of impeachment. And it is therefore important, my lord, in the interest of all of us, that these matters are resolved expeditiously and timelessly, so that this court can move to the next phase. The next phase, my lord, would be dealing with the question of the next step.
Good afternoon. Yes.
May it please you, my lord. Deputy Chief State Counsel, Charles Mutinda, Deputy Chief State Counsel, my lords and my lady, for the Speaker of the National Assembly, we have, and my lords and my lady, we have Mercy Tanchi for the 6th respondent.
Now that okay. We will supply after the proceedings of the day.
And my lords, your leadership,
I appear for Procedural. I think this is what we in E565 with my land friend, Mr. John, I haven't seen and then I also appear for myself. John.
two colleagues, Hosea Manwa.
Where are they?
Present, but not
Mr. Jose and who?
Hosea Manwa and Kevin Michuke.
Where's Kevin?
I am present, but not.
The man behind the camera.
Morning, this afternoon, and last evening when you were breaking, we were to come for a ruling. Perhaps you need to have clarity that we may not have a mixture of things.
We are dealing with the ruling matter.
Lord, Lady Gabas,
we have set out the structure of the ruling, but we'll begin from our analysis of the issues that we think are relevant for now. This is the ruling. Having carefully considered the pleadings, submissions, and evidence on record, we consider the following issues arising for determination. 1, what are the prevailing constitutional and statutory interpretation methods? 2, whether the Honorable the DCJ can assign judges pursuant to Article 165, Sub-Article 4 of the Constitution. 3, other related matters. On the first issue, the Constitution is a document sui generis. It is the ground norm which legally commands superiority and dominance over any other laws, and its interpretation, as of necessity, must be in a manner that all other laws bow to. The court in S versus Atchison, 1991, captured the centrality of the Constitution as follows. The Constitution of a nation is not simply a statute which mechanically defines the structure of government and the relationship between the government and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. In the matter before the court, the High Court has once again been called upon to address the issue as to whether the Honorable the Deputy Chief Justice of the Republic of Kenya, whom we refer to herein as the DCJ, can exercise the power of assigning and empaneling expanded benches of the High Court. As such, the interlink between Articles 161 sub-Article 2 and Article 163 sub-Article 1 and Article 165 sub-Article 4 of the Constitution, as well as Section 5 of the Judicial Service Act, come into play. On that score, it is paramount to briefly look at how the Constitution and the statutes ought to be interpreted. As a starting point, the Constitution itself provides for its own theory of interpretation. That is in Article 20, sub-Article 4, and Article 259, sub-Article 1. Article 20, sub-Article 4 requires courts, while interpreting the Bill of Rights, to promote the values that underlie an open and democratic society based on human dignity, equality, equity, and freedom, and the spirit, purport, and the objects of the Bill of Rights. Article 259, sub-Article 1 commands courts to interpret the Constitution in a manner that promotes its purposes, values, principles, advances, and rule of law, human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. In hailing the Constitution of Kenya as a highly transformative one, courts have over time developed various methods or canons of interpretation. In the case of David D. and others versus Attorney General, the learned High Court judges dealt with 4 constitutional interpretive principles, being that the Constitution must be interpreted holistically, that the Constitution does not favor formalistic approaches to its interpretation, and it must not be interpreted as one would a mere statute. the Constitution has provided its own theory of interpretation to protect and preserve its values, objects, and purposes, and that in interpreting the Constitution, non-legal considerations are important to give its true meaning and values. The Supreme Court, in the matter of the Kenya National Commission on Human Rights, Supreme Court advisory opinion reference, which I've given at paragraph 26, answered the question as to what holistic interpretation of the Constitution means. The court stated as follows: but what is meant by holistic interpretation of the Constitution? It must mean interpreting the Constitution in context. It is contextual analysis of a constitutional provision, reading it alongside and against other provisions, so as to maintain a rational explication of what the Constitution must be taken to mean in the light of the history of the issues in dispute and of the prevailing circumstances. In the case of Tiny Fuza as Attorney General, which I've given, citation I've given, the court was of the firm position that the Constitution must be read as an integrated whole. The court observed as follows: the entire Constitution has to be read as an integrated whole, and no one particular provision destroying the other, but each sustaining the